Well, it's my pleasure to introduce to you my friend, as you can tell, Doris Buss. Doris is an associate professor at Carleton University's Department of Law, and there she teaches courses and she supervises students on research on human rights-related subjects. I first met her, though, when she was a lecturer at Keele University in England, teaching law there. Professor Buss has degrees from Carleton, Dalhousie, and UBC. Her own area of research interests focuses on feminism and international law and politics, with a particular focus on religion and on sexual violence. She's the recipient of numerous awards and grants. In addition to her teaching and research at Carleton University, she's also the chair of the Board of Directors of LEAF, the Women's Legal Education Action Fund. This is the national chair, which I think she's nuts. It's a huge job. I don't know how she manages it on top of a full-time academic career. And she's also a member of their law program committee. So please join me in welcoming Doris to Robson Hall today.
Thank you. And what Karen didn't mention was the first time we met, I invited her over to our cottage in North Wales, not mentioning the fact that we'd actually already invited a whole group of people, and she had to sleep on the floor, which was a 200-year-old stone cottage on an air mattress that kept deflating during the night while Karen was freezing to death. So it's amazing that she still allows me in the same room with her. So I'd like to thank Karen, and I'd like to thank Deborah, and I'd like to thank the Faculty of Law for inviting me. It's truly an honor to be here and to be given a chance to talk about my research. And so thank you all for coming. So the paper I want to talk about today is published in a longer format. It just came out in Feminist Legal Studies, and I forgot to bring a copy of it, but it's available online. I can give you the citation. But it's part of a larger project I've been working on, which very loosely could be described as a project that's looking at the way identities are enacted and shaped by international criminal war crimes trials. And I'm particularly interested in the work of the Yugoslav and Rwanda tribunals. What I've become interested in quite more recently is a little bit about how the tribunals construct their own narrative of the history and the nature of the conflict in the regions, and I'm interested in studying that narrative. International criminal law, as I think most of you will know, is a reasonably new area of international law, or at the very least it's an area of international law that's had a very recent growth spurt. It is an interesting phenomena because the questions that are dealt with by an international criminal court on war crimes trials are not simply about adjudicating individual guilt. They are actually asked to do a lot more work than that. They can be thought of in the way I've been thinking about them as drawing from the work of Jerry Simpson, is to think about international criminal law as politics in a different key. And by that I mean that the decision to frame issues around harm, issues around conflict, issues around violence in terms of criminality, and particularly in terms of individual criminality, is itself a political move. Whether or not we think that criminalization of certain types of wrongs is a good or bad thing, and I actually have to confess to having some misgivings about the undue celebration of international criminal law, it remains that international war crimes prosecutions necessarily do a lot more than adjudge individual guilt. What I'm going to talk about tomorrow when I present at the Morrow Center is a work that's a little rougher than what I'm going to present today, which is looking at one of the issues, which is how individual responsibility is balanced off against collective responsibility. For my purposes today, what I just want to flag up is that war crimes trials are asked to do a number of kind of broader political and social work around ending the cycle of violence. They do this apparently through holding individuals to account. They end what's referred to as the cycle of impunity. They're meant to be a performative articulation of collective denunciation of certain types of behaviors. And so you can see that you need to read, I would argue, you need to read the judgments of the Rwanda and the Yugoslav tribunal, not simply in terms of their adjudication of individual guilt, but also reading them on all kinds of different levels about how they understand and frame the nature of harm, the nature of conflict, the stories that are told in the judgments, what types of harm are visible in the judgments, what types of harm are not, which categories of victims are entitled to speak before war crimes tribunals and which categories are not. So in my talk today, I want to focus on one particular category of harm, and that's rape as a weapon of war. And I'm particularly interested in how it is prosecuted by the Rwanda Tribunal. And the argument I'm going to make today is this, that although there are many good reasons to prosecute rape as a weapon of war, and although the Rwanda Tribunal does a lot of very good work, I think that there are some unintended consequences in prosecuting rape as a weapon of war. One of those consequences that I'm going to talk about today is that I think one of the effects is that rape ends up being treated as almost a natural, possibly an inevitable outcome of a conflict understood in terms of ethnic identity or ethnic genocide. And my concern is that in the text of the tribunal judgments, all violence is reduced to the equation of Hutu men who rape Tutsi women as a means of destroying the Tutsi community. And while this equation is not inaccurate, it doesn't actually capture the full complexity of why and how sexual violence was part of the genocide. But my real concern is that the overall effect of prosecuting rape as an instrument of the genocide is that it limits the types of questions that are asked about sexual violence and about the nature of violence surrounding the genocide. Understanding rape as an instrument of the genocide leads away from questions about why rape happens. Okay, so what I'm going to do today is 3 sections. The first is I'm going to give a really brief overview of the Rwanda genocide on the basis that most people can have a basic understanding of what happened. Then I'll talk a little bit about the record of the Rwanda prosecutions coming out of the Rwanda Tribunal and give you some statistical breakdown of what's happened. And then third, I'm going to lay out my more contextual argument about the problems of categorizing and naturalizing rape. Okay, so Rwanda is a very tiny country, and I have a laser. So it's here in those little tiny blobs in the middle of Africa. It is a very beautiful country. This is a map of Rwanda itself. For people who are in African studies or know something about Rwanda, the geography of Rwanda is actually quite important because the genocide unfolded very unevenly across the country. And those of you who know something about Rwandan history will know that a large part of what was going on in the genocide was a political contestation between the north of Rwanda and the south. And so the patterns of the genocide are quite different depending on which region. This is just a shot of the northern part of Rwanda. It's a stunningly beautiful country, very small. It's called the land of 1,000 hills, and there are hills everywhere. Okay, so the tribunal. The genocide. So most of you will know the genocide happened in 1994. It lasted for about 3 months. It started on April the 6th, which was the day that the plane carrying the president, Habyarimana, was shot down as it approached Kigali airport. It's not clear who shot the plane down, and it instigated the genocide. But actually, the events that immediately led to the genocide started much earlier. They started on October the 1st, 1990, which was when an army of expatriate Tutsi, invaded northern Rwanda. The invading force, the Rwanda Patriotic Front, is now the government of Rwanda. The army was made up primarily of Tutsi, though there were a few Hutu as well, and they were expatriate Rwandans primarily living in Uganda. The genocide ended in July 1994 when the RPF seized effective control of Kigali and the rest of Rwanda, at which point the then Hutu power government left the country, forcing over 1 million Rwandan civilians to go with them, causing a humanitarian disaster. In the roughly 100 days of the genocide, approximately 800,000 Rwandan Tutsis and some moderate Hutu were slaughtered. They were slaughtered by their Hutu neighbors, religious leaders, teachers, doctors, lawyers, judges, all with the sanction and under the direction of the Hutu power government. The murders were committed at roadblocks as Tutsi and Hutu tried to flee different areas. They happened in churches and sports arenas where Tutsi civilians were encouraged to congregate for their own safety. They happened on hilltops where Tutsi civilians were able to fight off, ultimately unsuccessfully, their Hutu attackers for weeks and even months at a time. And they happened in individual homes as attackers pursued Tutsi and moderate Hutus whose names had been included on lists that were read out on the radio and otherwise circulated. Okay, so as you all probably know, the international community is widely chastised for doing very little to stop the genocide, even though it knew it was happening. But one thing it did do is after the genocide, through the Security Council, it established an international tribunal that would prosecute primarily the leaders of the genocide. That tribunal is an international court. It applies international law. It's not based in Rwanda. It's based in Arusha, Tanzania. It's made up of international personnel, of which Canadians form a significant percentage, some would say an overrepresentation of tribunal staff, particularly defense lawyers. And it was supposed to complete its work in 2008. It's still going. It's now supposed to complete its work in 2010. I'm not sure it'll make that date as well, but it is in the winding down process. Okay, so rape as a weapon of war. This is a phrase that gets an awful lot of attention. It gets picked up in the press. You see it in different official documents. But it isn't, as the bright-eyed and bushy-tailed among you will know, it's not a legal concept. And it really needs to be understood in its particular historical context. So and we have to go back to Yugoslavia for this, because when war broke out in Yugoslavia in the 1990s, and there were reports of systemic rapes of women in those various conflicts, the existing legal and policy apparatus was really inclined to see rapes of women as a byproduct of war. Something that happened, it was regrettable, but it was not in itself remarkable. So feminist lawyers and activists and a few remarkable journalists began to call attention to the way in which sexual violence in the Yugoslav conflicts were in fact systematic, they were pervasive, and in many respects the evidence seemed to suggest that they were officially orchestrated. This understanding of what was going on in Yugoslavia ended up being captured by the phrase rape as a weapon of war, and it really was a claim that rape was not random. It appeared to be carried out as a deliberate policy, and thus it should be treated with the same political and legal urgency as other atrocities. And in fact, this is what has happened. Rape as a weapon of war, as that kind of articulation laid the groundwork for the subsequent legal recognition of rapes as a crime. And that's been determined by both the Rwanda and the Yugoslav tribunals. Okay, so I'm going to just focus, though, on what the Rwanda tribunal has done. I'm going to note, just in passing, that there's also a debate about the definition of rape itself. With the Yugoslav tribunal tending to one definition, the Rwanda tribunal tending to another. It's not a debate that I'm going to get into, because I'm not sure at the end of the day it actually makes a difference in how prosecutions unfold. Okay, so rape as a crime against humanity. So what you need to do if you're going to prove rape as a crime against humanity is that you show that there was an individual act of rape, but that it took place as part of a widespread and systematic attack against a civilian population on national, political, ethnic, racial, or religious grounds. Okay, so it's an individual act, but in a larger context. Similarly, rape as genocide refers to an act of rape that was committed with intent to destroy in whole or in part a national, ethnical, racial, or religious group. And then there's an underlying series of categories of events that would constitute genocidal acts, of which most rape as genocide tends to be prosecuted at the Rwanda tribunal as constituting subcategory B, sorry for the non-lawyers in the group, which is causing serious bodily or mental harm to members of the group. Okay, so again, you have an individual act, in this case of rape, but that takes place against a larger act, in this case an intent to destroy in whole or in part a community. Okay, so how does this play out in the tribunal? So this is the case of one case of Michele Muhimana, who was a counselor in Kabui, Western Rwanda. And he was accused and found guilty of participating in and abetting rape as a crime against humanity. The tribunal held that the rapes took place at the same time as a discriminatory widespread attack against a group of Tutsi civilians in Gishiti commune. And hence the tribunal found Muhimana criminally liable for committing and abetting the rapes charged as part of a widespread and systematic attack against a civilian population, hence a crime against humanity. Similarly, in the much lauded Ikiesu decision, which was the very first case prosecuted at the Rwanda tribunal, Jean-Paul Ikiesu, who was a mayor of Taba commune in South Rwanda, who actually resisted the genocide initially, but like many local authority figures, he was pressured by political actors in Kigali to get in line with the genocide, which he did, and he ended up being convicted of aiding and abetting rapes committed as acts of genocide. And you'll note that the tribunal makes a very important finding here that the rapes that were committed under the authorship or under the authority of Jean-Paul Ikiesu were aimed at the physical and psychological destruction of Tutsi women, their families, and their communities, and that sexual violence was an integral part of the process of destruction, aiming to destroy the women, their communities, and the Tutsi group as a whole. Hence, rape, and they find, and this is historical, it hadn't been determined until this point, rape could constitute the underlying act for the crime of genocide. Okay, so that's kind of the way the law functions in this area. And it is true, and there is ample evidence that rape was enacted in the Rwanda context as an instrument of the genocide. And I in no way am trying to minimize that evidence, which is quite persuasive. But what I'm going to do in the following section is I'm going to argue that if you look at the body of decisions coming out of the Rwanda Tribunal, you'll see two very divergent trends. And I suggest that those divergent trends have the effect of homogenizing sexual violence and homogenizing it as an instrument of the genocide. And I'm going to argue that that becomes somewhat problematic. Okay, so the record of the Rwanda Tribunal, if you read it as a whole, is pulling in two different directions. On the one hand, a significant number of judgments recognize and treat almost as a fact that women were raped in large numbers in the genocide. At the same time, you have on the body of decisions read as a whole, the fact that rape against individual women is largely absent from the record of convictions. And let me explain how that works. Okay, so I've done this reading up until December 2008. Apologies, it's a little bit out of date. So up until that date, there were 48 men who had had full trials on their merits. Okay, and of those 48 men, 15 went on to trial with charges of rape included on the indictment. So most of the men were not charged with rape. 15 were, and of those, only 5 eventually ends up being convicted of rape. If we look at the guilty pleas, as of December 2008, 8 men had pled guilty. Of those 8 men, 5 had initially had charges of sexual violence included in the indictment. The prosecutor's office agreed to waive all of those charges in exchange for guilty pleas, so no men have pled guilty to rape at the Rwanda Tribunal. The overall effect is that statistically, rape charges are disproportionately likely to fail at the Rwanda Tribunal. And there's all kinds of reasons for why, but the vast number of indictments do not result in convictions, vast numbers, because even the men who are convicted often have multiple rape charges against them, and the prosecutor's office is lucky if it gets one conviction. So the other trend is this, that there's of the roughly 29 judgments, because a lot of the men are tried collectively in 2s or 3s, so you have 29 judgments on the merits up to the end of December 2008. 15 of those, so over half, make recognition at different points in the judgment about the phenomena of rape or sexual violence against women. So the fact that only 5 men have been convicted is balanced off against the fact that rape and sexual violence is present in the record of the decisions, but in a different way. So the paradox is this. So although the Rwanda tribunal largely fails to prosecute individual rapes, it repeatedly acknowledges the widespread and instrumental quality of sexual violence against Tutsi women. Rape is obvious on the record, but few individuals are actually held responsible for rapes. Now, there is a small body of scholarship, including work I've done, that says, well, here's how you could do prosecutions better, and clearly there's a lot of problems in the Office of the Prosecutor. But I think in a way that moving so quickly to how could we make this better overlooks another problem, and that's the fact that there's an apparent easiness in seeing rape against women as widespread. Much more difficult to prosecute, but it's easy to recognize. And I'm interested in why there is this apparent easiness. So if you look at the body of decisions where rape is recognized almost as a fact that happened, you'll find phrases like this. It's well known that. It's widely accepted that. It's an established fact that rape was widespread in the genocide. In the longer version of this paper, I argue that there is a relationship here between what I would suggest is the almost hyper-visibility of violence against women in the genocide and the relative invisibility of actual individual acts of rape against women, that one allows the other to happen. For my purposes today, what I want to draw from that is the fact that what I see happening in the body of decisions is that rape functions here, the recognition of the widespread dimension of sexual violence against women, functions as almost a signifier of atrocity. In this respect, rape as an instrument of the genocide structures the types of rapes that can be spoken of and the categories of victims who can be recognized by the tribunal. I want to suggest that when you read the tribunal judgments as a whole, what you see happening is the tribunal is producing its own narrative of pain, its own narrative harm, which has been referred to by a South African sociologist as a grammar of pain, through which identities of victim and violator emerge. Rape is understood as a weapon of genocide, a conflict, an instrument of the war, positions rape as almost inevitable. Part of when the conflict is understood as either ethnic or nationalist. And I want to suggest that conceiving of rape as an instrument that one side picks up and uses against the other side assumes that rape is always available as a weapon. And it assumes that women exist as always rapeable or as inherently rapeable. That is, rape follows from the very existence of the conflicts understood as occurring between two polarized sides. So by gender grammar of violence, I want to suggest that what's happening in the decisions is that rape almost follows a certain script. Hutu men rape Tutsi women as a means to attack or destroy the Tutsi community. And this rape script, I want to suggest, has two consequences for the types of harms that are seeable and the types of victims that are seeable. First, it reduces all rapes and sexual violence to this equation: Hutu men violate Tutsi women. It assumes that all identities of Hutu, Tutsi, male and female, are pre-existing the conflict and that they're stable throughout the conflict, when the sociological and anthropological evidence suggests that this is not the case. The second effect, I think, is that rape as a modality of violence is treated as relatively uniform in practice and experience. The emphasis is on shared patterns of violence: Tutsi women attacked by Hutu men, and continuity of impact, the destruction of the community, rather than considering the variances and exceptions. The result is, as Fiona Ross, an anthropologist from South Africa, would say, based on her review of the Truth and Reconciliation Commission, is that the subject of violence is construed as naturally gendered, and the sociological problem to be explained becomes women's experience of violence rather than violence itself and its links to gender and power. So I want to suggest that the tribunal's narrative of the rape script, where Hutu men rape Tutsi women as a means to destroy the community, while not inaccurate, is only a partial account. And I want to finish my talk today by telling you two stories. They're two stories that are drawn from academic articles published by anthropologists about the genocide. And I think that they help to illustrate some of the complexities around who are seen as victims and the relationship between how harm and victimization are co-constituted. I'm not suggesting that they're a better truth than what's offered in the Rwanda Tribunal, but just that they help us to see the work that the Tribunal is doing in framing the analytical territory. Okay, so the first story is the story of Sarah Finn, and this is a story. Sarah Finn is a woman that was interviewed by an anthropologist named Jenny Burnett in 2000. And Sarah Finn was living in Kigali then, and she was living in Kigali in 1994. She was married to a Hutu man, and she had 4 children. Within 24 hours of the death of President Habyarimana, Sarah Finn's husband was called to a meeting, although the meeting actually ends up being a ploy to gather Tutsi men together to kill them. Sarah Finn's husband suffers severe head wounds, but he makes it back home. She hides him throughout the whole of the genocide, but allows rumors to circulate about his death so that no one will come looking for him. The result, though, is that a Rwandan army soldier starts to force sexual relations with Sarah Finn, who he assumes to be alone. Sarah Finn can't reveal that her husband is alive because he will be killed, and so she puts up with the sexual violence. At the end of the war, Sarah Finn is ruled to be not entitled to any kind of benefit as a result of surviving the genocide. And this is despite the fact that her husband's head wounds are so severe that he can't actually work. And Sarah Finn is seen as being not a genocide survivor, which is a new category of identity in post-genocide Rwanda. And the reasons are because she's a Hutu, her husband did not die, and because her neighbors saw the government soldier at her house, Sarah Finn is rumored to be an accomplice. Okay, so the second story I want to tell you is about Beatrice. Beatrice was also a genocide survivor, and she told her story to a journalist over a period of several years in the period immediately following the genocide. Beatrice was living without a husband, but with a daughter aged 10 and a son aged 6 in Kigali. And she had been living in the Muslim area of Kigali. She had recently converted to Islam. Beatrice's parents were from Zaire, which is now, as many of you will know, the Democratic Republic of the Congo. And so Beatrice had a Zairean identity card. So Beatrice and her 2 children, together with a friend from her Islamic community, a woman named Letitia, and her baby, flee Kigali, as many did in the early days of the genocide. Letitia, however, is Tutsi, and it says so on her identity card. As they try to make their way to the southwestern border of Rwanda, they are, as all Rwandans were, stopped repeatedly at checkpoints. Because Letitia's card identifies her as a Tutsi, Letitia tries to change her identity card, but she gets continually raped anyhow. Beatrice says that she buys Letitia's survival many times with money that Beatrice's brother had given her. While she downplays her own experience, it can be assumed that Beatrice herself was also raped at multiple times. Eventually, Beatrice's 10-year-old daughter starts to attract far too much attention at the checkpoints. And so a Hutu friend named Mama Naima takes her daughter and son as her own, and the group parts company, agreeing to meet up again in Siangugu. Letitia and her baby, unfortunately, are not so lucky, and eventually Beatrice can no longer buy their survival, and they are killed. Beatrice and her children do eventually rendezvous in Siangugu, and the interviews with her were done in Bujumbura, Burundi. Now, neither Beatrice nor Sarah Finn's stories are very unusual. They share many similarities with the stories that you would find if you read the numerous Human Rights Watch reports and Africa Rights reports of the genocide. But what those 2 stories do is they distill some of the complex dynamics around the genocide, particularly as they relate to identity. And they also highlight the difficulty in talking about ethnic categories as though they were stable and absolute throughout. They also reveal the importance of other kinds of social locations in framing individual experience of the genocide. Beatrice's experience, for example, is framed by a number of factors. Her identity did not strictly conform to the Tutsi category. Her patrilineage, Zairian, gave her some protection in some circumstances. She was part of a Muslim community in an otherwise largely Christian country. She had access to resources, money and friends, and she had assistance from Hutu friends and strangers throughout her whole ordeal, and she was incredibly tenacious. She also suffered enormously, and she died in 1998. Seraphine, as with Beatrice, survived in large measure because of good luck. But as a Hutu woman married to a Tutsi, she had a stronger position than Beatrice. She benefited from her patrilineage through her father that defined her at different points in the genocide as Hutu, but at different points she would not have been securely identified as Hutu. It changed over the course of the 100 days. The government soldier who abused her also probably protected her. And like Beatrice, Seraphine survived in large measure because of her ingenuity. Neither Beatrice nor Seraphine fits the category of Tutsi women. Beatrice is Zairian, and she's Muslim, and Seraphine is Hutu. Both of them, however, were raped and suffered abuses. And one of the things I explore in my paper is how the definition of rape as an instrument of the genocide, whether prosecuted as a crime against humanity or as genocide, has the effect of defining Hutu women out of the category of victims. They are impossible to see as victims for all kinds of reasons. Equally defined out of the category of victims are men who suffered sexual violence during the genocide, though there is evidence that both Hutu men and Tutsi men were raped at different points in the genocide. They become impossible to see in the rape script. Okay, so what should we conclude or take away from this analysis of the limits of rape as an instrument of the genocide? I mean, clearly I think the Rwanda Tribunal has done some very good and important work. Clearly, I think that there are times when prosecuting rape as an instrument of the genocide is very important. But there are also some limitations in the tendency to homogenize the experience of sexual violence. And I want to suggest that the tribunal's use of the phrase or the conception of rape as an instrument of the genocide is certainly much more formulaic than was originally intended by feminist activists in the 1990s. But for my purposes, what I see happening in the tribunal body of decisions is that the questions that should be opened up and that maybe are foreclosed a little bit in the way that rape as an instrument of the genocide is told, that the tribunal ends up depicting rape as almost inevitable. We see rape as naturally resulting from certain kinds of conflicts. And when we do that, I think we're in danger of forgetting to ask, what conditions, structures, power relations make violence against certain categories of women and men possible at sometimes more so than others? Rather than homogenizing sexual violence against women, I think there is an alternative approach, which is to focus on what actually happens in rape situations, to listen to the stories of women like Seraphine and Beatrice, to understand the details of what happens to them. Because it's at the level of detail, with all the inconsistencies and complexities revealed, that it becomes possible to imagine a situation where rape is not inevitable. Thank you. Yeah, so the Rwanda Tribunal, as you know, operates under international law, not Rwandan law. So there is a parallel process going on in Rwanda where rapes were classified as a particular category. So all crimes committed in the genocide were reduced to particular categories. The category then dictated which kind of mechanism would address them. Rape was alongside of genocide, constructing the genocide, were seen as the category of crimes that were so serious that they could only be prosecuted in a court. So post-genocide, the Rwandan government did change its laws to strengthen the way it defined rape and the way it prosecuted it. Because the Rwandan courts ended up not being able to handle the volume, very recently, in the last few years, the Rwandan government has taken that category of crimes, including rape, and has said that they are now eligible to be addressed through the informal customary law system of gacaca, which is justice on the grass, is generally how it's understood. And that is much more informal. There are real problems with that move in that the protections that were given to women when testifying in a court in Rwanda just aren't in place when you have a communal process. So the existing law that was changed to allow for this provided that if a woman wanted to bring a charge of rape, through this informal mechanism, she could ask for it to go what we might think of as in camera. It wouldn't be out in the open. It would have a separate hearing. But of course, the moment you do that, everyone's going to know, what's going on. Rwanda is a populous, small country, but everyone knows everybody. Everyone knows what's going on. So it would be almost impossible, I would think, to bring a rape charge in that context. And I don't think they are being brought, because the people that ended up bringing the rape charges within Rwanda itself were women who were dying, who had nothing left to lose. And they're not going to use that process. Does that answer your question?
This is really interesting to me, and maybe people don't know where it came. Some of that idea of being an aberrational thing that is happening with these kinds of problems.
Yeah, no, I think you've hit on a really important point, and it's something I've struggled with as a feminist, because I'm used to sort of thinking about the ways in which the legal system erases the systematic nature of violence against women, or the systematic and systemic aspects of inequality. And here I have the reverse problem. And I've found it difficult to frame what it is that I see happening that makes it feels very slippery to me. Because there's also another related problem. If those of you who studied criminal law, you'll know that part of the concern is around when a rape prosecution is brought, the fact that the focus invariably is on the woman, the victim, the alleged victim. And part of the critique is, she is the one who ends up defending her conduct and her decisions, and shouldn't the focus actually be on the accused and what he did and why he made the decisions he did? And it's really about trying to shift that focus. And here, I have the focus is shifted. Is the women actually are really quite invisible. Most of them are dead. This is part of the problem. But I had the reverse problem. I want their stories, but their stories are really, really hard to hold on to in these decisions. I don't know if anyone's read any of these tribunal decisions, but they just go on for hundreds and hundreds and hundreds of pages with all kinds of amazing levels of detail. And yet you lose sight of the individuals very easily in a way that you don't lose sight of them in the human rights reports. So it is a really difficult issue, and so I'm not clear what the answer. I'm not sure there is an answer to the problem, except it is about the need to put front and center the fact that there's a relationship between widespread violence against women and everyday violence against women, and we need to think about what are those connecting points, what are those relationships. It's the sociological question of what is the relationship between power and violence. Which I think is what we're losing sight of. Mm-hmm. Mm-hmm. Yeah. I mean, I think you've hit on a key nugget here is the tension around criminalizing individualized guilt in a post-conflict scenario versus other kinds of processes of trying to hear and understand what happened in the post-conflict period. And I have to confess to being really conflicted individually. The criminal law is a very limited and blunt instrument for this kind of work. At the same time, there can be quite powerful effects in criminalizing individuals. I interviewed an expert about, this is for the Yugoslav part of the project, who had been an anthropologist in the period leading up to the wars in Yugoslavia, so she got to know her community quite well, and she visited her community, which was in the Muslim Croatian area of Bosnia. She visited them throughout the wars, and then in the post-war period, and she said, at that point, the Muslims had all been forced out of this tiny village by their Croatian neighbors and by the Croatian army. And they wanted to come back and the war was over. But the local thugs were still in power. So the war was over, but the local thugs were preventing the Muslims from coming back until one of the local thugs was prosecuted by the Yugoslav tribunal. And physically that removed him from the community, and the Muslims who had been forced out of their home were allowed to return, or felt they could return. So while I am really skeptical of criminal law, I also think that there is something about ending that cycle of impunity that can be incredibly important for just the raw act of a community, individuals being able to pick up their lives again. And this is true in Rwanda as well, because of course many of the power relationships that allowed the genocide to take place in the first place are still in effect. It's just there's different people in power, but some of the power holders are still around. And removing individual power holders can be important.
I'm fascinated by the labeling of what I think. What happened, the big and then create the derivative. What would it be?
Well, and I think it's important, first of all, to say that the tribunal is not writing a headline. So the tribunal has hundreds of pages to write its decision. And it avails itself of complex expert evidence. Much of that evidence does align with what I've said today around the anthropology of identities in the conflict. But the tribunal hasn't, despite given the opportunity, has still insisted on seeing the Rwanda genocide in terms of an ethnic conflict that actually begins, in the way they use it, to look a lot like a race conflict. This ends up being, despite their best efforts, a representation of tribal conflict. So I suppose what I would rewrite is those terms. I would urge the tribunal to stay away from the terms Hutu and Tutsi. To actually just look at vulnerable populations because people were vulnerable in different ways at different times. And the tribunal is doing the work of producing a record, and it's not a bad record. It's a reasonably nuanced one, yet it holds on to this very sort of primordial understanding of identity categories. That's where I would start the work. But it's an excellent question, and one I hope I dodged successfully. Sure. Oh yeah, the errors, I think there's a huge lesson to be learned here in the errors, what went wrong. So originally there had been a specific sexual violence team that was disbanded by the chief prosecutor, Carla Del Ponte. And she is alleged to have said, and I don't know this for sure, but she's alleged to have said, I'm a woman and I can do this because I can get away with it. So she disbanded the sexual violence team. The investigators that they used tended to be white men, often ex-RCMP officers, who went into remote Rwandan communities to do interviews with no guidance or training or knowledge of how you do sexual violence interviews. So they just didn't find any evidence. When they did find evidence, they discounted it. So it didn't make it into the investigation reports. Prosecutors routinely, time and time again, fail to draft proper indictments. They missed deadlines repeatedly, so that a number of cases were thrown out just because the prosecutor's office just didn't get its act together. The indictments get thrown out a lot. They still do. The indictments are badly drafted for a whole range of crimes, not just sexual violence. But in the interviews I did, I spent some time at the court in Arusha a year or so ago, and the interviews I did with court staff confirmed that sexual violence crimes are disproportionately affected by the problems with the indictments, and they were described as a plague on the sexual violence prosecutions. And then the actual prosecutions themselves were confounded by bad witness preparation, failure to support witnesses. One woman, her husband she testified first. They're all testified under a pseudonym. They're supposed to have witness protection. It's often very, very faulty. They're in a very small community in Arusha where everybody knows everybody. Although it's Tanzania, it's still a very small community. And she testified about her rape. She was actually kidnapped and held hostage as an effective sex slave for a while. She was able to escape, and she reunited with her husband. He was giving evidence the next day. When it was his turn to give evidence, and the prosecutor asked him if he was married, he said no. And she, of course, is quite confused because the prosecutor knows that, in fact, he is married. He was married to the witness that testified the day before, and he said, no, I'm not married now. So he had effectively just divorced his wife because he had found out that she had been raped. He should not know that. That evidence was released and he shouldn't have. So witnesses were very reluctant to testify. Some of them were very badly treated on the stand. There's an infamous occasion when the judges and the prosecutors and defense lawyers burst out laughing during a woman testifying about her rape. Now, there was a reason why the translation process in these tribunals is really quite complex. So there's 3 languages at play. There's English, French, and Kinyarwanda. All the translations go through French first. So you go English, French, Kinyarwanda, Kinyarwanda, French, English. And it takes time. And every stage of the translation, invariably somebody interrupts because you also have a room packed full of lawyers, packed full of defendants. And so they're constantly interrupting, which throws off the translation, and so things are really delayed. But that makes it incredibly stressful for the witnesses who don't speak French or English and they don't know what's going on. Many of them have never left their village before. They travel from Rwanda. There's no direct flight, so they go from Rwanda through Nairobi. They spend the night in Nairobi. Has anyone here ever been to Nairobi? One word you'd use to describe Nairobi? Dangerous, crazy, chaotic, incredibly busy. So they spend the night there, never having left their village. So they've now traveled to Kigali for the first time, gotten on a plane. They've gone to this ginormous city of Nairobi. They've spent the night. Then they go to Arusha, where they wait around for weeks on end for their turn to testify. So often that evidence collapses on the stand. So those are some of the factors that went on. Thank you. And can I make one announcement of my own? So at Carleton, we're also hosting a 2-day special international workshop on sexual violence and conflict in Africa. So if anyone's interested, we're inviting a series of service providers and practitioners from Africa and Canada, as well as academics who are doing research on the area. So if you're interested, it's taking place in May at Carleton in Ottawa. I'm sure you could apply for a grant to get there.
Just on behalf of the faculty, the staff, and students here, and in fact the university community, I want to thank you, Doris, for a really interesting talk and for getting us thinking about, I think, really important issues. So thank you for coming. Thank you. Something small.